So this is the issue which we have taken, the topic which we have taken. So issue which we are going to cover today, that if I want to prove an SMS, what the compliances I need to do, and or from the defense lawyer, what would be the cross-examinations. So we are going to discuss this issue because I have received so many requests. So I thought that in this way I can So first, when we go to the court, deal with that SMS, whether it is a document, whether it is an object, what type of called as a electronic record under. So electronic records electronic form. What do you mean by the record? Then we term it as a message in the electronic form. It is a electronic record. But when I transfer it into a pen drive and I give it to someone, then I refer it as a electronic form. So these are the two definitions which you must know what is the difference between. So within so here I have referred to the two prominent judgments, Dharamveer versus CBI, then which is from in both the judgment, the court have clarified in very explicit word that electronic records are documents. So you can use any of these judgment if required during the court proceeding to prove this point that they are a document. Because once they are a document, not an object, then you have so many rights under the Evidence Act how to deal with that particular electronic evidence. Now coming to when we are going to see, there are two important issues with the SMSs. We have to prove the admissibility and we have to prove the authenticity. So how to prove the admissibility and authenticity? First, we are discussing how the message a person narrates who is having the connection of the Airtel, send a message to the person Ram, which is with another service provider. So here, your message travels from the Naresh to Airtel, then to the another ISP, and then it goes to the RAM. So basically, where you can find the original copy of the messages, one original copy would be the Naresh who is sending it. Then the another copy would be with the Airtel, service provider of the Naresh. So there will be 4 copies which are in original. So if we refer legally how we can term all the 4 copies as the original. So there is an explanation to the section 62 of the Evidence Act, which says that if the number of copies of a document are prepared by technical means, then all are the original. So that means the document which travels coming to the WhatsApp. In case of WhatsApp, there is no server. So the data packet which travels, it is from the user to the destination. So we can say from the source to the destination, and meanwhile it passes through the various hosts. So it passes through the network of the WhatsApp. In the network, a temporary copy is being, but there is no server which maintains. So if we talk about the original copies, so the original copy would be with the sender, and original copy would be with the receiver. Now come to the very important thing which we need to understand is that what is the burden of proof. So if it is a criminal case, how I can prove a particular electronic evidence or how I can rebut. See, there may be cases where you may be responding to an electronic evidence which is a forged. Then how you will discharge? So first let us come to the criminal cases. So when message strict, that means they have to prove it beyond doubt. So when we refer to the term beyond doubt means that there is no possibility of manipulation. So the opposite means if a particular burden on the prosecution is the strict proof, but burden on the opposite side. Suppose if I am a defense counsel on the opposite side, manipulation. Now, be careful. For example, if a witness has produced some SMS, and if during cross-examination I give him a suggestion that is it correct that if he has filed the SMS in a secondary form in the form of a printout, and I give him a suggestion, is it correct that it is possible to manipulate such SMS in a Word file? Now my burden is discharged because I have established the possibility of manipulation. Another possibility of manipulation can be done in another way. For example, if a seized by the police but not have been deposited into the malkhana at the same time, so I can always give him a suggestion that it is which is on the defense to rebut the evidence is only the possibility of manipulation. So that's why during cross-examination, study, then we try to bring how the evidence can be manipulated and what is the possibility of Delhi. The Division Bench of Delhi High Court have laid down certain factors which the court need to look into. So what are these factors? Number one, who are the person having the access control to that some particular evidence? For example, then there is a large possibility that it can be manipulated. Another is the storage mechanism. What was the storage mechanism and in whose control it was? When the exhibit was opened by them, when they did the forensic, and when they closed the forensic examination. So we try to examine the entire chain of custody. So that is the during the prosecution of a particular offense, prosecution evidence. Now come to the defense evidence. Now if I am into defense and I am leading the defense evidence, the burden which is on me is not the stick. It is the burden by the preponderance of the probabilities. Because see, cases of the prosecution is into the same power is not with me. I cannot discharge that strict burden. So under the criminal jurisprudence, the burden which is on me, on accused, is by preponderance of probability. So I can show, sir, this is the message. So this shows so and so, and I can corroborate it with the other evidences. So that is the burden which need to be discharged at the stage of a defense. Now, in cases of the civil proceedings, it goes by the preponderance of probability on both the sides, because both the sides, they are not the police officials. They will present that evidence before the court and try to convince the court with the various evidences which are into their possession. So in case of civil, the best approach is to be support any fact by the various corroborative evidence, not only the one evidence. Then there are a number of other principles of interpretation which are to be which are being followed. For example, if you send me a document, let us can I prove that particular evidence, sanctity of that evidence, authenticity of that evidence beyond doubt? No. Because I have the only copy which you have sent to me. So there is another principle of interpretation. In that case, what I have to do, I have to prove that I have received this particular attachment from you. The moment I am able to prove that fact, the burden shift to the opposite party, burden shift to the now in the electronic world, when there are number of copies of every electronic evidence, let us take, for example, let us take an example of SMS or WhatsApp. During trial, I am proving the WhatsApp message, and you come to the court from the opposite side, and you rebut that message, and you say that message is electronic evidence. I have created the message. I have sent you the message. Original message is with me. I have sent you the message through online. Now you say that the message is forged, but you have in your it is incumbent upon you. Now, ये आपकी responsibility है. It is the obligation on you that you bring that message which is into your possession to rebut that it is the message which I have sent to you, or message which I have shown in the court is a forged one. So since you have a copy, but now what happened? You come to the court during cross-examination, you rebut, but you do not produce the message which is into your possession. So because you have the opportunity to rebut it by confronting me with the message which is into your possession. So apart from the law which is laid down in the Evidence Act, there are so many principles of interpretation which are applicable, which shift the burden from one party to another party. So another example I give you, and a very interesting case, in one of the cases where recently one of the court in Jalandhar have convicted one of the accused. So what happened in that particular case? Now, the message which was received by the girl from the accused now at the stage of interesting plea, and his plea was that this message is for you say it is forged, to whom the burden will lie, because burden will shift on you, because it is being recovered from you. Now you have to discharge that burden. If you say that it is forged, the burden is on you to prove. it is false, and ultimately that person was convicted. So it's about 2 months back. To have a very clear visibility about that. So when we talk about the SMS, when we talk about the mobile of the sender, each would be with the intermediary. So that is the same chart which we have discussed. So here the message would be with the 4 parties, right? The original message, right? Now, second, you connect the mobile from someone, and when he got registered the FIR, and FIR was registered. So it was not the original. What do you mean by FW? And his answer was, it is a second, we can change. And there would be forged message. Now, in such cases, if you take a printout or so, just I'm going to show you the video. Lab. From the beginning. Now, this is a software which is SMS. Now you can see on the top of it, there is an application which is called as a SMS editor. You can now we have selected one of the message. So this is the message which is sent by Ravi to the webber. Now this is the content of the message. Now what we did, now we are trying to change the content of the message. Now you see, this is a message. Now we are changing the content of the message, right? Now we have altered the content. We have saved the particular content of the message. See, now it was a simple message. We make it a obscene. Application, now we have made the main application. Now in the mobile, the specific skill which can be done, and that's why when you produce the secondary evidence, it is one of print out. So what is the option available? Now again, I am showing to you how you can change the content of the WhatsApp messages. So just a minute, let me show the application which we are using. So this is the application WhatsApp. It is available freely on the internet. Now, if you want to create any fake WhatsApp message, you can simply download on your mobile. And after that, it gives you an utility to create any fake content by any name. You can, so here I've created a contact Ravi, and then I've created one of the message. So this is a fake message, and this application is only for can be prosecuted on the basis of the fake messages, and in case of a secondary evidence, there may not which is created is a fake message. Now it contains obscene content, and during the and you have produced only the screenshot or the printout, can I rebut it? Because there is no way by which I can prove creating a fake SMS, creating a fake WhatsApp message is something which is like dangerous to rely upon the secondary evidences. So that's why it's also very important for us to understand that how during trial why you cannot rebut it. So this is very important. Authenticity, veracity. And we ultimately decide whether this particular document is or not. So that is a procedure in case of document. Now let us come to the take an example, a case of SMS. Now, if it is a you have filed a screenshot or you have filed a printout, it is a secondary evidence. You have attached a certificate under section 65B. Now come to the cross examination. Let us take an example of forged message, and I have shown you how it is easy to forge the message. Produce only the print. I do not have access to that particular mobile until I have the mobile into my possession. What maximum I can do if I'm on the opposite side and I know the message which is being produced by the witness is the forged one, maximum thing I can do is I can give him the suggestion that is it correct that this message is a forged one. And in that particular case, I do not have the capacity to rebut that particular evidence. I do not have the fair opportunity to defend myself. Is when a party is producing the secondary evidence, the opposite party will not have the sufficient opportunity to defend that particular type of evidence. So you keep that thing in mind. While doing the cross-examination, you can always give a suggestion that since this is a secondary evidence, I do not have the access to the mirror image or the original evidence. So then certificate under section 65. So basically it is a if there is an electronic evidence, that is the first requirement. Second is that the information is derived from the information which is fed into the computer. Under section 65B3, we have the two presumptions. Presumption number one, if there are a number of computers in a network, for example, you take the example of any office. If in any office there are 100 computers which are connected to the server, then for the purpose of section 65B, they would be treated as one computer. Again, if there are number of computers in succession, for example, you execute a transaction on the ATM and till server it get root through the large number of computers. But for the purpose of section 65B, they would be treated as one computer. Then what should be the content of the certificate? Content of the certificate are the electronic record which you want to prove. For example, if you want to prove the SMS, so in your certificate it would be written that these are the messages, the printout of which is attached here with the certificate, right? So that would be the description of the messages. Then the device which has produced these electronic record. Then the compliance of all the conditions relating to the computer and relating to the information. So for your help, I have given the link of our website where you can get the performa of certificate under section 65B for the mobile. Same you can alter it to make it compatible for the WhatsApp messages. And who can give the certificate? Certificate can be given by the person who is in charge of a computer or a person who is the part of management of relevant activities. So when we talk about the mobile, so it is basically the person in whose possession the mobile was and who is using it. So that particular person can give the certificate under section. Even if you take the help of any other person to retrieve the message, that does not make any difference. Certificate under section 65 we still have to given by the person who is the owner or in charge of that particular mobile, both in case of WhatsApp message and also in case of the SMS. But one thing you need to keep in mind is that when we talk about certificate under section 65B, it only deals with the admissibility and not authenticity. Right? So authenticity we need to prove. So how you can prove the message? If it is your original message, so what we have discussed is where the original message is, it would be admitted as a primary evidence. So in case of the message SMS, the original message would be only into the mobile or in the server of the service provider. But server cannot be brought to the code. And if the service provider gives you a printout, it could again be a secondary evidence, not the physically examined. Because I have told you how easy it is possible to forge or manipulate the message, and all the applications for doing the same are available free of cost on the internet. And until you do the forensic examination, you cannot verify the authenticity of the message. Now coming to the secondary evidence, for admissibility, you need a certificate under section 65B along with the printout or data and CD/DVD by whichever means you are giving authenticity. So authenticity is one of the big challenges. As we have earlier also discussed that in case of secondary evidence, it is not possible to verify the authenticity. So there are two ways by which you can do. Number one is you can get it forensically examined. For example, if you have to give your mobile to the police for any purpose of evidence, what you can do, you can get your mobile forensically examined from a private forensic lab, and then you can give the printout along with the screenshot, along with the forensic report. So then authenticity would be at higher level, right? Second is you have in your possession the original mobile containing the original message. And when at the time of the evidence or at the time of the cross-examination, you can produce the original mobile and you can show the original message either to the court or to the defense if so asked, right? But preserving it takes years, right, during the trial. So you may not be able to preserve it. So that so in case of the SMS, there are 4 parties, and in case of the WhatsApp, there are 2 parties. For example, when we talk about the SMS, which is sent by the person Naresh to the person Ram, so there are 4 parties. One is the Naresh, second is his service provider, so it would not be Rediff, it may be Airtel or Vodafone. Similarly, the Ram has its own mobile. Then his service provider would be either of one, Reliance, Jio, Vodafone, whatever may be. So there would be the four parties. Then under section 88A, there is a presumption of correctness. And how this presumption operates? This presumption says that from point A to point B, the data is presumed to be correct. When there is a presumption in law regarding the correctness of the content, certificate under section 65B is not required from service provider. So then who can give the certificate under section 65B? It can be given by the person who is sending the message. It can also be given by the person who is receiving the message. So who can give the certificate under section 65B? So the person who is into the possession of the device, its owner or its in charge. When certificate cannot be given, if the original evidence is destroyed. For example, you have an original message into your mobile. You have given the message to the police, but you have not given the 65B. And after a while, police comes to you again asking for the certificate under section 65B. But by that time, you do not have that original message into your mobile, then you cannot give. So this is the new judgment of the Supreme Court in Arjun Panditarao. Then issue is, see, now we have discussed both the way. One is what is the original and what is the secondary. But the question arises whether you need to give the original or whether you need to give the secondary. How will you decide? And particularly keeping in view that there is no provision either in the Evidence Act, CPC or CRPC regarding when to give the original or when to give the secondary. So it is a matter of prudence. So there are three factors you need to keep in mind. Number one, interested witness. If you are a witness who are interested into the outcome of the case, in a criminal case, you are interested into the conviction of a case. So then you may have all the reason to forge it or manipulate it. So in such cases, you must give the original if you want that particular message to be proved beyond doubt. Because if you will not give the original and the opposite party gives you a suggestion that it is correct, that message can be easily forged. So certainly then the original part, the opposite party would be in a position. Second is preservation of original. So original need to be preserved. And if you are not able to preserve the original till the time matter came for the evidence during trial, so it's better you should give the original. Because if the original is destroyed, the veracity of the secondary evidence you have given would be no more. Now this is the latest judgment of the Supreme Court. Third is the corroborative material. For example, your message is only one of the evidence to prove a fact and there are other evidences as well. So if there are other evidences as well, then you can give a secondary copy because then the court will read that secondary copy in the light of the other evidences which are available on the court. So when there are level. So now preservation of the original. So now in Arjun Panditarao, this is a very important proposition, right? This is likely to affect a large number of cases. So what the Supreme Court has observed, the Supreme Court has observed that if a person who gives a certificate under section 65B but failed to secure the evidence, that means you have given a 65B, but now you are not able to preserve the original. To secure the evidence, now you have preserved the original, but you have not given a certificate under section 65B along with the secondary. In both the cases, the data cannot be verified. So now the important two questions which comes during cross examination to a witness: can you produce the original evidence? For example, if you have given a message by taking the printout from your message, probably after a couple of years you may not have the same mobile, because now what is happening? Every year we are changing the mobile, and if you do not have the mobile and your answer is that now I cannot produce, my question would be, is it correct that without original, authenticity of the message cannot be verified by the court? by the lordship, and lordship cannot match the original with the copy, certainly your answer would be yes. And I would be able to prove that the message, all the possibilities that the message could have been manipulated, and that is the only burden I need to discharge. I am not required to prove that it is actually manipulated. That is not the requirement of the law. Now coming to the stage when certificate under section 65B can be filed. So certificate under section 65B should be filed before the trial in criminal cases. So now this is the from the latest judgment of the Supreme Court in Panditarao. But it can also be filed at a later stage if the court is of the view that no prejudice is caused to the accused for want of fair trial. So that means the ultimate objective is, even if you are not able to file during the investigation of the police or during the at the stage of at the stage of charge, you can give it thereafter also, but you need to give prior to the examination of the concerned witness. For example, if I have to give a certificate under section 65B, then I should give it before I am being examined or at the time of my examination, but not thereafter. But it cannot be filed after the trial. Now, what should be the objection? Now, suppose a witness comes to the court, right? He has already given a secondary evidence in the form of a printout of a message or WhatsApp message, but he has not given a certificate under section 65B. So, whether you will get the benefit of this? Answer is no. For getting the benefit, you have to raise the objection. And when you have to raise the objection is the moment the witness comes to the witness box and prove a particular message, its authorship or the ownership, then you have to give the objection to the court and court will note it down. Or otherwise, what you can do, you can put in the form of a question during cross-examination. For example, I have referred to the two sample question here. Is it correct that no certificate under section 65B have been issued by you? Because if there is no, you will say yes, I am not issued. Is it correct to suggest that you are not competent to issue the certificate under section 65B? Because this certificate under section 65B falls into the category of the mode of proof. So if you have the two type of objection, number one, you have not given the certificate. Number two, you are not competent to give. So both the objections you have to raise at the time when the cross-examination is being done, but not thereafter. Then coming to the requisite, how to confrontation during the cross-examination. Now what is happening? In 138 cases and in other cases, parties have all the option to do the recording using the spyware, using the mobile or using other various devices. And what the parties are doing? They are doing the recording. And at the time when the witness comes to the witness box, we can always confront if he is speaking something false. So how that is to be done? Now, let us come to a situation, a witness is into a witness box and you have your mobile containing message and you know that what the witness is speaking is false and you want to confront them with the message. The simple procedure is that when the witness make a deposition, chief is completed, during cross-examination, you can ask the question that whether you have sent such and such message to me stating the fact so and so. Now the witness says yes, then you can always confront with the mobile and it would be an admitted evidence. Now, if you have shown it to the witness and witness said no, then you have to prove the requirement of certificate under section 65B and also its authenticity. So better in such cases, when you are going for confrontation, get the mobile forensically examined from a forensic lab and confront it with the mobile, but also keep ready your forensic report if the situation so demands. So during confrontation, you may get so many challenges that may ask what is the source of that particular message. If there is no source, you will not be able to prove that particular evidence. Best way to prove the evidence is if there is a corroborative material, you can give a secondary evidence with a certificate under section 65. So you can give the printout or a screenshot with the certificate. But if there is no corroborative evidence, you have to give the original evidence, and you have to it has to be proved by the owner or in charge of the mobile, and the forensic examination should be conducted beforehand to prove the authenticity of that particular message. Now, so here this is one of the case where we have made the message inadmissible. So it is a very interesting case. What the accused did, accused has taken the SIM in the name of his friend and sent the message through that particular mobile. So the message were threatening, they were the abusing message. They were being sent to the large number of MPs, going to the more than 80 MPs. So the case was, the charge was framed under section 506 IPC and 6060. Sorry, charge sheet was filed. Now, at the stage of charge, what happened? In that particular case, the police have neither seized the original mobile. Police have also not taken the printout. So there was no primary, there was no secondary. What the police did, they have taken the message in a handwritten form. So at the time of the argument on charge, so we claimed before the court that since neither the primary evidence have been taken, neither the secondary have been taken, so it is not an evidence at all. So it is a case of zero evidence. So despite the fact that there are around 5 or 6 FIR on the same issues, all the court simply discharged them because there is no legally admissible evidence. So if you have any query, you can always send us the email, or you can also go to our YouTube channel and you can put the comment. So wherever possible, we will try to assist you and help you in prosecuting or defending whatever may be the cause which you are pursuing. So if you have any question, we can now take the question from the participant. So the participant can unmute themselves and ask the question.
Sir, my question is, hello sir, good evening. This is Prashant Mani. My question is, if person is accused, and can third party can give 65B certificate, or maybe subject matter expert?
So Prashant, in that particular case, the 65B has to be given only by the owner of the mobile or in charge of the mobile. See, there can be two situations. Either I can be owner, but if the mobile is given to me in official capacity or in my any capacity as a, for example, the mobile belongs to my relatives or my parents, and I am possessing the mobile as a user. So I can give as a user. So if I am an owner, I can give as a owner, right? No one else can give. No third party can give a certificate under section 65.
Thank you, sir.
Right? So anyone else? Any other question?
Yes, sir. Yes, sir. This is Divya Bansal. Sir, I wanted to understand that you said that you can give your mobile to the private forensic lab for authentication.
Ji.
Yes, sir. Sir, private forensic lab, when we want to prove that evidence, so any person will be called from there to prove the content?
Yes.
Or it will be...
and have to prove that particular report. And there would also be cross-examination. But the very interesting part here is that when you do the forensic using the UFED, what the UFED do, it makes an image of the entire mobile. So that particular expert can make a deposition before the court that how he has arrived at the conclusion and how he is going to prove the authenticity.
Okay, UFED, is it an app or something, sir?
It is one of the costliest software of rupees 16 lakhs, one of the best software, which is the result of which are admissible in court.
Okay, so if we ask our clients to get it authenticated, there are private labs which are there in Delhi or NCR area.
Every place in every city there are few labs.
So another question which I have is, if we give our mobile phones without forensic, is there any possibility police can also alter the content of the phone?
Please come again.
If we give the accused or the complainant give their mobile phone to the police, when police gives you a seizure memo and we do not go to forensic lab, there could be a possibility that even the police can change the content of the mobile by using these softwares which you said.
Police can always change it, but there is a procedure. Whenever they will seize it, they will seal it. And they will put a stamp on it, seal on it, and then they will deposit it in a normal. So that's why when we do the cross-examination on the opposite side, we try to see whether the chain of custody is established or not.
Yes.
So then you have to bring all these facts on record during your cross-examination.
Okay. Okay. So we have to prove the custody of the chain.
Chain of custody.
Thank you, sir. Thank you. Thank you.
You're welcome. Yeah. Anyone else?
Sir, in continuance of the question asked by a participant, that the lady, sir, I want to ask that, sir, if I deposit, if I'm suppose I'm an accused of a cybercrime, and the police seized my phone and my laptop, what if the police manipulated the data inside that? How can I check that?
See, whenever the police produces that, you think that it has been manipulated in any manner. So there are a number of ways by which you can do. One is that you can rebut the chain of custody. And in the mobile, it is quite easier in a number of ways. For example, if the mobile is seized from you and after that there is any modification, then they have to open the mobile. And sometimes when they open the mobile, lot of things are automatically downloaded. We know as of now, you are getting so many messages which even are unwarranted. So you can just look into the mobile to see whether there is any message which has come thereafter, whether there is any call which have been made. And like particularly in case of WhatsApp, whether the police want or not, the message would be automatically downloaded. Have been manipulated. You can make a request to court to get it forensically examined, but at the stage of defense. So you have all the method, but you need to know how to exercise these remedies.
Sir, can I ask you one more question?
Sure, sure.
Yes, sir. Sir, if we give the mobile to the police, do we do not have to give the SIM or along with it, or we can just hand it over without the SIM?
See, normally SIM is not required, but if you have preserved certain data into a SIM, police may ask you to give the SIM. In that case, you can obtain the duplicate SIM. Normally, it is not required, depending upon what evidence the police want from that particular SIM to be proved. If there is no evidence which is required from the SIM, then that is not required.
And if we are giving for WhatsApp chats, then
okay, right. Thanks to all of you. Still, if you have any question, you are most welcome. You can send it to me through the email and you can post on our YouTube channel. So thank you. Thanks to all of you.
Thank you so much.
Thank you.